A registered sex offender is not a member of a protected class protected by the fair housing laws. Facts. During her representation of a potential tenant, the licensee discovered that the prospective tenant was a registered sex offender. The agent is uncomfortable and wants to terminate the agency relationship. Issue. May the agent terminate the agency relationship because the prospective tenant is a registered sex offender? Discussion. Assuming that the reason for the desired termination is that the prospective tenant is a sex offender, the agent may terminate the relationship. Registered sex offenders are not a protected class under Arizona state or federal fair housing laws. See note. Age-restricted community must allow disabled child issue. A buyer wants to purchase a home in an age-restricted community. The buyer has a disabled child who must live with the buyer to receive proper care and treatment. Can an age-restricted community prohibit the purchase of a home by a buyer with a disabled child? Answer: probably not. In general, age-restricted communities are exempt from the fair housing laws prohibiting discrimination against families with children. This exemption does not apply, however, to a person with a disability. The Arizona Court of Appeals has ruled that the refusal of a homeowners association to waive the age restriction to allow an underage disabled person to reside with his parents violated the reasonable accommodation requirements of the fair housing laws. Kennedy v. Prescott Canyon Estates Homeowners Association, 204 Arizona 91, 60 P3D, 231, AP, 2002. SU note. Agent should not ask for letter of introduction. Facts. The seller received multiple offers on a property. Several of those offers had letters attached introducing the buyer and telling the seller a little about the buyer. The listing agent contacted the agents who had not presented a letter of introduction, asking if they wanted to submit a letter of introduction to the seller. Issue. Did the agent violate fair housing by asking for letters of introduction? Answer. See discussion. Discussion. The Federal Fair Housing Act makes it illegal to discriminate in the sale of real estate on the basis of a person's race, color, religion, sex, handicap, disability. Familial status includes children under the age of 18 living with parents and legal guardians and pregnant women. National origin. A letter of introduction could provide the seller with information that might lead the seller to reject an offer on the basis of a protected class. Therefore, the best business practice would be to refrain from asking for letters of introduction if they were not offered voluntarily by a buyer. Apartment complex must reserve parking for mobility-impaired tenant. Facts. A mobility-impaired tenant has issued a demand for a reserved parking space near her apartment, despite the fact that the complex offers ample unassigned parking and does not have any parking spaces marked as reserved. Issue. Must the apartment complex grant the tenant a reserved parking space? Answer. Yes. Discussion. Pursuant to fair housing regulations, a landlord must make reasonable accommodations in rules, policies, practices, or services if necessary for the disabled person to use the housing. Atheists are entitled to the religious protection under fair housing laws. Issue. The seller is a deeply religious individual and does not want to sell his home to someone who is not religious. Specifically, the seller wants the listing broker to advertise that the home will not be sold to atheists. Do the fair housing laws protect atheists in the sale of homes? Answer. Yes. Although atheists are not formally religious, atheists as an irreligion are entitled to the protection of the fair housing laws. Board of Education of Curious, Joel Village School Dist. V. Grumet, 512 U.S. 687, 114 SCT 2481, USNY 1994. Therefore, the listing broker cannot advertise that the home will not be sold to atheists. A call for highest and best does not create an auction. Facts. Broker A listed a property in the MLS. Broker A received 8 offers. Broker A notified all 8 buyers that the seller would like everyone's highest and best offer. Broker B has filed a complaint stating Broker A is conducting an auction. Issue: is a call for highest and best an auction? Answer: no. Discussion: the function of an auction is to permit the highest bidder to purchase the property offered for sale, and the choice of that highest bidder is therefore beyond the control of the seller. Winfield Collection, Latade, 105 F. Subtude at 749. Here, the seller received 8 bids to purchase the property and proceeded to request the best offer from each of the 8 buyers. Therefore, seller had control of who would purchase the property, and Broker A was not conducting an auction. A seller may require that a particular title company be used only if the seller pays all associated fees. Issue: can the seller choose the title company provided that the seller pays for the buyer's owner's title policy and not require that the buyer purchase their lender's title policy from the same title company? Answer: see discussion. Discussion: Section 9 of RESPA provides, no seller of property that will be purchased with the assistance of a federally related mortgage loan shall require directly or indirectly, as a condition to selling the property, which title insurance covering the property be purchased by the buyer from any particular title company. See 12 U.S.C. Paragraph 2608. The Department of Housing and Urban Development, HUD, has indicated that it will not enforce Section 9 of RESPA against a seller who selects the title insurance company if the seller is paying for the owner's title insurance policy, and does not require the buyer to use the title insurance company for the simultaneously issued lender's policy. HUD would take action under Section 9, however, in situations where a seller required a buyer to pay the seller an amount towards closing costs, and the seller used a portion of the buyer's paid closing costs for the owner's title insurance without providing the buyer with a choice of that title company. Husband and wife must sign personal guarantee. Issue: the buyer purchased vacant land with a small down payment and with seller carryback financing for the balance of the purchase price. The buyer had bad credit, and the seller required the buyer's father to personally guarantee the promissory note and deed of trust for the seller carryback financing. The buyer's mother did not sign the personal guarantee. The buyer's mother and father have been married for more than 40 years. After closing, the buyer discovered environmental problems on the vacant land and has now stopped making payments on the seller carryback financing. Is the father liable under the personal guarantee for the delinquent payments on the seller carryback financing? Answer: although the father is liable under the personal guarantee, the liability is limited to the father's sole and separate property because the mother did not sign the personal guarantee. The community property of a husband and wife is only liable under a personal guarantee if both the husband and wife sign the personal guarantee. CARS, paragraph 25, 215. Inasmuch as the mother and father have been married for more than 40 years, however, the father probably has little or no sole and separate property.